Welcome to Lesson 1.7, Understanding Regulatory and Contractual Requirements, Part 1. In your Candidate Information Bulletin, we are in the Security and Risk Management domain. We are in key area of knowledge C, compliance, and our topics are going to include privacy, privacy issue, transborder data flow, and some U.S. privacy and security regulations. So let's start with defining privacy. Privacy is the right of an individual to control the use of his or her personal information. And privacy regulations pertain to the collection, the information sharing, the disclosure of personal information such as social security numbers, financial account numbers, passwords, PINs, driver's license numbers, a passport number, and your healthcare or educational records, or even your financial records. This information set is often referred to as either PI, PII, or NPPI. That's personal information, personally identifiable information, or non-public personal information. So you may see any of these three, PI, PII, or NPPI. But in all cases, they pertain to personal information. Information security is the process by which we safeguard information in systems and we ensure confidentiality, integrity, and availability. So privacy and information security are closely related, but they are different. Privacy, again, is the right of the individual to control the use of his or her personal information. So let's look at some privacy concerns. Data warehousing combines data from multiple sources into a large database for the purpose of data analysis and retrieval. You'll sometimes hear this referred to as big data. Well, you can start seeing where there might be a privacy concern when we start taking all of these various disparate databases and put them together, because let's see what can happen. We have data mining, which is the process of analyzing the databases with tools that look for trends, correlation, and anomalies. So we put all of this data together, and then it starts getting mined for looking at these trends. It may be from a personal perspective, what activities you are doing over a period of time. Data aggregation is when individual pieces of data are combined to create a bigger picture. So I take information from the insurance company, some information perhaps from a pharmacy, some information from a government agency, and when you put those pieces together, you start creating a bigger picture. So each of those individual pieces are not so significant. Put them together, aggregate them together, and they can become very significant. And the third is data inference, which is the ability to derive information that's not explicitly available. So in an inference situation, the data isn't sitting there in black and white, but you can say, wait a minute, if this is true, and this is true, and this is true, well then that must be true. And so it's a way that you're inferring from the information that you have. Well, from a privacy standpoint as individuals, a lot of information is collected on us every single day. And when that information is warehoused together, when it is mined, when it is aggregated, and when data is inferred, there's a very good chance that we lose control over our own privacy. So combined, mined, aggregated, and inferred data all have the potential for misuse. So this is really a concern across the globe, and a number of countries have adopted laws and regulations to ensure that their citizens do have a right to privacy. Privacy is a global concern as it increases the need for government action, and there are a number of countries that have enacted very, very specific and stringent privacy regulations. So we're going to look at a couple of them. The first is Canadian. It's the Personal Information Protection and Electronic Documents Act. This Canadian privacy law governs how the public and private organizations can collect, use, and disclose personal information in the course of business, and it applies to all private sector companies doing business in Canada. The next is a Mexican law, which is the protection of personal data held by private companies. This law requires organizations to have a lawful basis, such as consent or a legal obligation for collecting, processing, using, and disclosing personally identifiable information. It applies to all Mexican businesses, as well as any company that operates or advertises in Mexico or uses Spanish language call centers or other support services located in Mexico. The European Union Data Protection Directive, EU DPD, is a very stringent law that sets strict limits on collection and use of personal data and demands that each member state set up an independent national body responsible for the protection of this data. This directive applies to all EU businesses as well as companies to which data is exported. The European Union Safe Harbor Act was intended to bridge the different privacy approaches of the United States and Europe, and enabling U.S. companies to safely engage in transatlantic transactions without facing interruptions or even prosecution by European authorities. Key provisions include that companies compliant with the Safe Harbor Act will be deemed adequate, and claims brought by European citizens against U.S. companies will be heard in the United States, subject to limited exceptions. And lastly, we have COPPA, which is the Children's Online Privacy Protection Act, which took effect in 2000. This is a United States law and applies to the collection of personal information from children under 13. It's monitored by the FTC, that's the Federal Trade Commission. COPPA limits how companies may collect and disclose children's personal information, what a website operator must include in the privacy policy, when and how to seek consent from a parent, and what responsibilities an operator has to protect children's privacy and safety online. Affected by this regulation are operators of commercial websites and online services directed to children under 13 that collect personal information from children, as well as general audience websites with actual knowledge that they're collecting personal information from children. All of these regulations primarily focus on protecting the privacy of personal information, but however, integrated in all the regulations is the requirement also to safeguard confidentiality and integrity. In addition to local laws and regulations, we need to consider transborder data flow. The Internet facilitates the transparent movement of data across the globe. Information may be created in one country, transmitted through others, and stored in yet another. That's particularly true in a cloud-based environment where very often a consumer doesn't even know what country their data is in. It's absolutely imperative that security professionals know where their data is, where it's being transported to, and agree that their data can be stored in those locations. Security professionals need to consider on a global scale the privacy and security regulations, or lack of the countries where their data is transmitted through or stored, the access of local governments to stored or transmitted data, and the law enforcement jurisdiction if there is an incident. So let's do a lesson review. We started out talking about privacy, and we said that privacy was the right of the individual to control information about themselves. We looked at some privacy concerns, including data warehousing, mining, aggregation, and inference. And in Lesson 2, we're going to be looking at some OECD principles of privacy. We looked at global privacy laws and regulations, and we discussed transborder data flow and the importance of knowing what country your data is being transmitted through and what country your data is being stored in. So let's go to a Lesson 1.7 and match the meaning. The terms that I want to make sure you're very confident in are privacy, data warehouse, data mining, data aggregation, data inference, COPPA, EU Data Protection Directive, and transborder data flow. As always, the terms on the right-hand side are all mixed up, so put me on pause, go ahead and match up the meanings, then come on back and we'll go through them together. All right, let's go through Lesson 1.7 terms. The first is privacy, and that's the right to control one's own information. Next is data warehouse, and that's a large collection of data. That's generally when we have combined multiple databases into a large collection. Data mining is when we analyze for trends and patterns. Data aggregation is when we take pieces of information and we put them together, and that creates a bigger picture. Data inference is when we can derive information from the information that we have. So once we have mined data, once we have or aggregated data and we put it together, we can then make some other assumptions. We can derive other information. COPPA is the United States law to protect the online privacy of minors. The EU Data Protection Directive is the European Union law that sets very, very strict limits on data collection and use. And lastly, transborder data flow deals with the movement of data across countries. This is where we need to consider where our data is being transported to and where our data is being stored. So we're going to end this lesson with our CISSP exam tips. I want you to remember that security and privacy have different but complementary goals, that they need to work together, that the Safe Harbor Act was intended to bridge the different privacy approaches of the United States and the European Union, and that organizations must always follow the laws and regulations of the countries that they operate in. So you need to be very, very aware of where you're operating and what the local laws, regulations, and customs are. Thanks a lot for joining me in this lesson, and I look forward to seeing you in the next.